Welcome to the EPG Pathshala in Criminology. I am Professor G.S. Bajpai of National Law University, Delhi. In this presentation, we will look at the Supreme Court landmark judgments on victims of crime, part 2. The learning objectives for these presentations are to sensitize the reader to the effects that the crime may have on the victims of crime, to familiarize with legal rules governing the protection and the redress for victims of crime, to identify steps that states must take in order to provide redress and protection to the victims of crime, and also to increase the awareness about the rights of victims of crime, to seek the substantive justice. Let us start with the introduction. It is quite pertinent to note that the victim is not a passive objective, but an active component of the whole judicial process. The victim deserves similar level of protection and attention from the court like that of an accused. To strike a balance between the human rights of the accused and that of a victim by a plethora of decisions, the Honorable Supreme Court of India attempted to restore the dignity of the victim and to heal up the wounds sustained by the victim. Post Court Criminal Procedure Amendment Act 2008 and Criminal Law Amendment of 1913, a radical shift is noted in the Indian criminal justice system that introduces and redefines the rights of victims to a significant extent. For example, Section 24(8) of Code of Criminal Procedure provides for engaging of an advocate of his or her choice to assist the public prosecutor. Trial of offences under 376, 376(a) to 376(d) of the Indian Penal Code, as far as practicable by a court presided over by a woman, is also given under Section 26(a). Further, the provision as to recording of a statement of rape victim of her at her residence or in a place of her choice are as far as practicable by the woman police officer in the presence of her parent or guardian or near relative or a social worker of the nearby locality are given under Section 157 of CRPC. Also, Section 173 1A provides in the criminal procedure which mandates a specific time of 3 months for the investigation agency to complete the investigation if the allegation relates to the offence of rape of a child. The Malimath Committee report in 2003 in chapter 6 strongly espoused the idea of justice to victims. This report highlighted the plight of the victims of crime in every criminal justice process and recommended the constitution of a victim support service coordinator to safeguard the interest of the victim at the trial stage. The national concern for victim was epitomized in the observation of the Honorable Minister, Home Minister Mr. Chidambaram in Lok Sabha in the Bhopal disaster debate, where he said 25 years later we can look back with a sense of regret and guilt that we did not address the grave matter that way it should have been. We, the Lok Sabha, must send a message that we share their victims a grief and sorrow and guilt. Now, let us turn to the discussion on rights of crime victims. Victims' interests need to be balanced vis-a-vis that of accused. Views to this effect echoed in the National Human Rights Commission versus the state of Gujarat and also in Vikas Kumar versus the state of Uttarakhand. The court observed that broader public and societal interests require that the victims of the crime, who are not ordinarily parties to prosecution, and the interest of the state represented by their prosecution agency, do not suffer even in slow process, but irreversibly and irretrievably, which if allowed would undermine and destroy public confidence in the administration of justice, which may ultimately pave the way for anarchy, oppression and injustice, resulting in complete breakdown and collapse of the edifice of the rule of law, enshrined and jealously guarded and protected by the Constitution. While considering the right of the convict to the released, the principles set out by the court in Arvind Yadav versus Ramesh Kumar were taken into consideration, and the court in State of MP versus Kusum observed that it is also to be borne in mind that the victim and the family of the victim who have suffered at the hands of the convict have also some rights. The convicts have no indefeasible right to be released, and while considering the imposition of appropriate punishment, the court must not only keep in view the rights of the accused, but also the rights of the victims of crime. In Delhi Domestic Working Women's Forum versus Union of India, the Supreme Court, while stipulating the broad parameters for assisting the victims specifically of the offence of rape, asserted that the victims ought to be given proper legal representation. The court further said it is important to have someone who is well acquainted with the criminal justice system. The role of the victim's advocate would not only be explained to the victim the nature of the proceedings, to prepare her for the case and to assist her in the police station and in court, but also to provide her with guidance as to how she might obtain help of a different nature from other agencies, for example, mind counseling or medical assistance. It is important to secure continuity of assistance by ensuring that the same person who looked after the complainant's interest in the police station represents her till the end of the case. Now, let us look at the victim's right to appeal. The Bombay High Court in Balasaheb Rangnath Khade versus the state of Maharashtra declared the victim's right to appeal as integral to the catena of human rights available to each individual, which are absolute and unfettered in nature. The court warned against the granting to the courts the prerogative to afford leave to appeal. One cannot afford to dilute the solitary vital rights which has been expressly been given to the victims in the Indian criminal jurisprudence. Let us now look at right to compensation to crime victims. In Sebastian versus Union of India, two women filed a writ of habeas corpus to produce their husbands who were found missing. The authorities failed to produce them. The court concluded on the basis of material placed before it that the two persons must have met unnatural deaths, and that prima facie they would be offences of murder. On account of failure of government, the Supreme Court directed the respondents to pay rupees 1 lakh to be given to each of the wives of the missing persons. The court in Valraj versus the state of UP held that the power to award compensation under section 357(3) of the CRPC is not ancillary to other sentences, but it is in addition thereto. The court held that where the amount fixed was repulsively low so as to make it mockery of the sentence, it would be enhanced the financial capacity of the accused, enormity of the offence, extent of damage caused to the victim are the relevant considerations in fixing of the amount. In a state of Maharashtra versus Christian Community Welfare Council of India, while answering the question whether the compensation paid by the state can be recovered from the officer or not, the court had, it will depend on the fact whether the alleged misdeed by the officer concerned is committed in the course of discharge of his lawful duties beyond or in excess of the same, which will have to be determined in a proper inquiry. If it is found that the appellant officer did not cause the death of the deceased and the same is not in the performance of their official duty or in the excess of the same, then they cannot escape the liability. In Mangilal versus State of Madhya Pradesh, Supreme Court in a landmark ruling held that the power of the court to award compensation to victim under section 357 CRPC is not ancillary to other sentence, but is in addition to thereto. Subsection 1 of the 357 deals with a situation where a court imposes a fine, a sentence including sentence of death, of which fine also forms a part. It confers discretion on the court to order as to how the whole or any part of fine recovered is to be applied. The court further held an opportunity of hearing has to be granted before granting payment of compensation under section 357(4) of the criminal procedure. Even if a statute is silent and there are no positive words in the act or the rules made, thereunder there could nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by the orders that may be passed, and making it a requirement to follow a fair procedure before taking a decision. Unless the statute provides otherwise, even in the absence of a provision in procedural laws, power confers in every tribunal court of judicial or judicial character to adopt modalities necessary to achieve requirements of natural justice and fair play to ensure better and proper discharge of duties. The application of natural justice becomes presumptive unless words of statutes of necessary intendments, its aim is to secure justice or to prevent miscarriage of justice. Principles of natural justice do not support the law, but supplement it. There has been mention of fair and reasonable compensation time and again, but what would be a perfect compensation is the confusing question. Faced with this similar dilemma, the court in Arvind Kumar Mishra versus New India Assurance Company Limited observed that perfect compensation is hardly possible, but one has to keep in mind that the victim has done no wrong, he has suffered at the hands of the wrongdoer, and the court must take care to give him full and fair compensation for that he had suffered. Now, coming to the victim's right to dignity, comfort, confidentiality and protection. In the state of Punjab versus Gurmeet Singh, the Supreme Court highlighted that an in-camera trial would aid in making the victim of crime more comfortable with not too many familiar and possible overbearing courtroom ambience. The victim could then answer the questions with ease. Such a procedure would be in tune with the need for safeguarding the victim's dignity and self-respect, and also likely to help elicit improved quality of evidence from the survivor. It addresses the issue of victim convenience. As such, attempt avoiding creation of a milieu wherein the victim is reduced to fight all sorts of pressure and influences, while constantly under the gaze of the public. The 2008 amendments made it obligatory for such trials to be conducted as far as practicable by a women judge or magistrate. Milestone in the path of cementing victim justice, restitution to victim has been one of the major target of the Indian Supreme Court for affirmative action. The apex court has made it sure it protects the rights of victims by adopting the concept of restorative justice and has been advocating award of enhanced compensation or restitution to the victims. State's liability to recompense the victims was recognized as mandatory in case of abuse of power in D.K. Basu versus the state of West Bengal and Rudul Shah versus the state of Bihar. For specific types of victims, the Supreme Court has time and again given concrete guidelines. In Bodhisattva Gautam versus Subra Chakravarti, Supreme Court held that if the court trying an offence of rape has jurisdiction to award compensation at the final stage, the court also has the right to award interim compensation. The court came to the rescue of the indigenous rape victims who cannot afford legal, medical and psychological services in accordance with the principles of UN Declaration of Justice for Victims of Crime and Abuse of Power 1985. In Delhi Domestic Working Women's Forum versus Union of India, the court gave the recommendation for setting up Criminal Injuries Compensation Board. The right of the victim to get compensation in a case where the death was caused by the negligence of a doctor has also been identified in a case. Victim has the right to be informed of the outcome of the investigation and to raise objection to the final report submitted by the police, asking for discharge of accused. Decision in Nilvati Behra versus state of Orissa and in Chairman Railway Board versus Chandrama Das are illustrative examples of the new trend of using constitutional jurisdiction to do justice to the victims of crime. Substantial monetary compensations have been awarded against the instrumentalities of the state for the failure to protect the rights of the victims. In Rajpal Singh versus the state of Punjab, the charge was under section 302 IPC, the complainant claimed the compensation under 357 and court had in this instant case did not have sufficient material before it to correctly assess the capacity of the accused to pay compensation. But keeping in mind the objective of the section, it was found to be fit case for the grant under the section. The court, having gone through records and materials, found that the appellants were reasonably affluent, hence it ordered the sum as found to be reasonable compensation in this case. Supreme Court in Mangilal versus State of Madhya Pradesh in 2004 held that the power of the court to award compensation to victims under section 357 is not ancillary to other sentences, but in addition to thereto. The basic difference between subsection 1 and 3 of section 357 is that in the former case the imposition of fine is the basic and essential requirement, while in the later even the absence thereof empowers the court to direct payment of compensation. Such power is available to be exercised by an appellant court, the High Court or Court of Session when exercising revisional powers. Victims' right of participation in the post trial stages of the proceedings stands on a better footing. An appeal against an order of acquittal can be preferred with the prior leave of the High Court, but both the state governments and the complainant. The right of a victim's near relative who was not a party to the proceedings to file a special leave petition under Article 136 of the Constitution, the Supreme Court challenging the order of the acquittal by the High Court was expressly recognized by the Constitution bench in PSR Sadanandam versus Arunachalam. The question of payment of compensation to victims of crime from the basis of prison labor came up for consideration in the state of Gujarat versus Honorable High Court of Gujarat. The court recommended that the state should make a law for setting apart a portion of the wages earned by the prisoners to be paid as compensation to the deserving victims of the offence, the commission of which entailed in the sentence of imprisonment to the prisoners either directly or through a common fund to be created for this purpose or in another feasible mode. Bhaskaran versus Shankaran, the apex court, while considering the scope of section 357(3) CRPC, laid down that the magistrate cannot restrict itself in awarding compensation under section 357(3), since there is no limit under subsection 3. Therefore, magistrate can award any sum of compensation. In Swarup Singh versus State of Haryana, the apex court emphasized that the amount of compensation in this case was enhanced, taking into consideration the gravity of injury, the strata to which the accused belongs, the milieu in which the crime has taken place, and keeping in view the cry of society for victims at large. Supreme Court has held in a state of Maharashtra versus Praful Desai that the recording of evidence by way of video conferencing might be done in cases where the attendance of the witnesses cannot be ensured without delay, expenses and inconvenience. The Supreme Court observed that the rights of an accused should not be overemphasized to the extent of forgetting that the victims has also rights. The Supreme Court in Lalita Kumari versus Government of UP and others, while citing references of its ruling in the state of Haryana versus Bhajanlal, reaffirmed that the position that is subject to certain limited exception as a matter of general practice, the police is duty bound to straightway record an FIR under section 354 under section 154 of CRPC, where the information discloses the commission of a cognizable offence. This has significantly cemented and strengthened for the victims the right to access to justice. In case of Muhammad Harun versus Union of India and other, Supreme Court highlighting the section 164A of CRPC, which provides for medical examination of the rape victim and casts a statutory duty upon police to send the women making complaint of rape to a registered medical practitioner within 24 hours from the time of receiving information regarding the commission of such an offence. In the present case, the police knowingly delayed the medical examination of the petitioners, who were all married women having children, were gang raped in Muzaffarnagar of UP. The medical examination was conducted almost 20 to 40 days after the incidents of the gang rape and is unlikely to provide any perpetrated evidences such as slackness in action by the police agencies, rendered the very purpose of the provision imposing an obligation defeated. Now, turning to conclusion, the Supreme Court judgments in India are increasingly inclined in favor of the accused. He gets all protection and privileges in the system. This is what Supreme Court is saying about accused. Not only he, means the accused, gets defense counsel at the cost of the state at the time of trial, but he is also benefited after conviction. The aftercare, reformative and rehabilitative programs for the accused are also at the rise. The punishment can be considered more as treatment, rehabilitation, correction and reconciliation through probation, parole and other care community services. The modern criminal law overlooks the byproduct of crime, that is the victim. The lack of victim oriented jurisprudence is the main cause of deterioration of the conditions of victims and their family members. The victim sets the criminal law into motion and then goes into oblivion. Being the protector of the civil liberties of the citizen, the courts have an obligation to grant relief in exercise of its jurisdiction under Article 32 and 2 to 6 of the Constitution to the victims or the heir of the victims, whose fundamental rights under Article 21 of the Constitution of India are established to have been flagrantly infringed, notwithstanding the right of the citizen to the remedy by way of a civil suit or a criminal proceeding was observed in SPS Rathod versus State of Haryana. So, it is worthwhile to mention that the gradual shift in the approach of the Supreme Court is a positive sign, but other organ of the government, that is the legislature, has to make a conscious effort to consider the rights of the victims. There are legitimate reasons to bring on par the victims of crime with the accused persons who have been bestowed with the constitutional right to have competent lawyers of their choice to put up the defense against the prosecution, but it is also a fact that the victims of crime or complainants alleging serious offences have least say in the entire trial, in which they alone have the biggest stake. Thank you.